I want to turn now to California's Proposition 8, which defined marriage as between a man and the woman. The state of California declined to defend this. We had a 5-4 decision today, sending it back down to the lower courts. Attorney David Rivkin is going to stay with me now. David, was today's decision really a punt by the high court? Do you think they just threw it out on grounds of standing because they didn't want to make a decision on the merits of the case itself?
Yes. The short answer, Mary, is yes.
Okay.
I think that, and this is what's interesting, you had a different coalitions here. What's interesting is that Kennedy actually was dissenting here, suggesting that they do. Incidentally, as you explained, what happened is the California state officials, the Attorney General in particular, abandoned the defense of this proposition that was duly passed by the citizens of California somewhere in the middle of a district court action. And then the people who stepped in were essentially the supporters, the leading, they call them sponsors of Proposition 8. And the court here did not reach any merit issues, Mary, said, we just can't allow this to happen. They're not the right parties to defend it. And from a constitutional perspective, you need to have proper parties both challenging and defending a statute. Now, you have Kennedy joining the
Thomas,
the four
Alito,
dissenters.
Sotomayor.
Yes.
I mean, it's really an odd grouping.
Right.
David, I wonder, does this have broader implications? I mean, if voters pass a ballot initiative by Democratic majority, does this mean that the state or a governor and attorney general can just decide, well, we don't like what the majority of our state passed, we're just not going to defend it, and it can be struck down?
That is, or fall under its own weight, not struck down, because remember, no challenge would ever reach the merits. You're going to get a default judgment. It's troubling, and what's also troubling is, again, the opportunity that you would evade a serious judicial review of a result. It's bad enough when the courts strike down something that was done for the proper political channels. It's even worse that it sort of collapses on its own weight because you can't even bring a meaningful legal challenge. But back to punting, it's interesting. I happen to think right now, Kennedy, of course, is a deciding voice on how you would deal with a state definition of marriage that excludes same-sex marriage. And what I would say, somewhat flippantly, but also seriously, I don't think that any one of the 9 justices right now knows which way, including Kennedy, knows which way he would rule when such a challenge will come to the Supreme Court in the next several years. So everybody punted. I don't think they were ready to decide this far more cosmic issue, which would, remember, DOMA was largely, albeit not completely, driven by federalism. If, on the other hand, you have a federal constitutional obligation to redefine marriage to include same-sex marriage, that is very much trampling on federalism. So it would be a very difficult decision for Kennedy. It's sort of pitting into conflict 2 key aspects of his legacy. 1, federalism. 2, his commitment to individual rights. I happen to think that Kennedy will come out the right way and federalism would prevail, but others can disagree.
David, we've got less than a minute left, so I'll be brief. Are we starting to see the character of the Roberts Court as a court that's afraid to make decisions that might be politically unpopular? You saw it in Obamacare. You saw it in Fisher v. the University of Texas. You saw it in the voting rights case that we got yesterday, Shelby. Is this good for the country to have a court that can't draw bright lines?
Is both. We do want the court to proceed incrementally and carefully. On the other hand, there are times, Mary, where an honest, straightforward decision is needed and it's not there. Now, I'm not prepared to blame Roberts for it. In part, you operate on the basis of the justices you have. So if you cannot get to 5 of a bold decision, you get to 5 of an incremental decision. That's the essence of being a Chief Justice.
David Rivkin with the last word. Thank you so much for such a clear analysis of these very complicated decisions. Appreciate having you on the show.
Good to be with you.